Yeah, we want to
Go,
holler,
boy.
holler, holler, holler.
Lamont, you like that?
Yes, I like that one.
Throw up both your hands, Cam.
Throw up both your hands.
Yeah.
Oh yeah, throw up both your hands.
Oh, okay.
This ain't living.
You stay muted, Mr. Bailey, please.
Yeah, y'all
Don't
can come
stop.
up in the courtroom, but I can't.
Beg your pardon?
Nothing.
Oh, I didn't think so. Okay.
Oh, I ain't think so. I'm just gonna repeat what you said. You said throw up both your hands.
No, I didn't say that, sir. That was not me.
Oh, I was
All right,
about to throw both my hands.
all
That's
right,
all.
all right.
I was about to.
Where's John Holler?
Okay,
the
there's
attorney? Is the attorney here?
Yeah, Mr. Holler, your client, and okay.
I don't see him.
What kind of? You must
Hey,
have
you
a
sound like a
small
man.
screen,
Hey, you sound
Cal.
like a man now.
Oh, there he is. Yeah, John, we're back.
All right, Mr. Holly, you ready?
I'm ready.
All right, Mr. Bailey, I'm calling your case 24-0556-2701, People versus Marvin Bailey.
Good morning, Your Honor. Cal Nazier for the people.
Good morning, Your Honor.
Where's the nitro camera not on?
Oh, yeah,
I don't see him.
Girl, okay.
Hold on, sir.
Yeah.
Mr. Holly, appearance.
John J. Holler on behalf of Mr. Marvin Bailey, who's joined us by the Zoom technology.
All right, Mr. Bailey, I need your name, sir.
Marvin Bailey.
All right, good morning. All right, Mr. Nazier, any offers here?
Judge, Mr. Holler emailed me some information yesterday to give me more to look at and read, and I've had email communication with him. Currently, the offer is no reduced plea.
All right, how you want to proceed today, Mr. Holler?
Well, the offer is no reduced plea and 2 years of probation. Isn't that right, Mr. Najjar?
Correct.
Okay.
With other conditions, that's correct.
Okay, with some other conditions to be determined. If we can do a situation where my client can pay in lieu of community service, something like that, we can take a plea today.
The courtroom session opens with immediate tension as the defendant interrupts proceedings with inappropriate remarks while still muted on Zoom. The judge quickly regains control, warning him to watch his language and behavior. Within seconds, viewers can sense this isn't going to be an ordinary plea hearing. The judge makes it clear that disrespect won't be tolerated, setting the tone for a courtroom exchange that spirals fast.
Bailey's camera's off.
I'm here.
All right, you understand what the prosecutor's offer is, sir?
No, I don't.
Mr. Nazier.
I don't even see the prosecutor. Who is the prosecutor? His camera's not on.
What does that have to do with it, Judge?
The offer that we've discussed is to plead guilty to carrying a concealed weapon without a license to do so, which is a felony. 2 years, a sentence agreement of 2 years of probation, and you will have the opportunity to pay.
Fuck them.
Prosecutor presents what appears to be a solid offer. Plead guilty to carrying a concealed weapon without a license, accept 2 years of probation, and comply with additional court-ordered conditions. Defense counsel even attempts to negotiate flexibility regarding fines versus community service. On paper, this is a manageable resolution to a felony charge, one that avoids prison time. The judge carefully explains the terms to ensure the defendant understands exactly what's being offered.
Okay.
Mr. Bailey, watch your mouth, sir.
Man, okay.
Here's what's gonna happen, Mr. Bailey. If you keep it up, I'm gonna bring you into the courtroom and take you into custody and find you in contempt. Settle down,
All
sir.
right, bro. All right.
That's the judge, it's not your bro.
All right. Sorry about that. Sorry about that, Judge.
All right, go ahead, Mr. Holler.
Okay, thank you, Your Honor. And at the time of sentencing, the court can determine that that Mr. Bailey would be able to pay a certain sum of money in lieu of community service if he so chose. So it would be like an either-or type of thing. So the court would determine an appropriate amount of community service versus an appropriate amount of additional costs or fines, however we want to characterize that he could pay at his election. He would be on probation for 2 years.
All right. Mr. Bailey, you understand what that offer is, sir?
Yes.
All right, you waive your right. Now you understand you have a right to have a preliminary examination, sir?
Yeah.
You waiving your right to have a preliminary examination today?
Yes, sir.
Anybody threaten you or force you to get you to waive your examination right today?
No, don't nobody threaten me.
All right, court's going to accept the waiver. Mr. Bailey will automatically be bound over. Mr. Holler, as it relates to the arraignment, he's standing mute and waives the formal reading of the information.
I do.
Court's going to enter not guilty plea
Hey,
today.
can I ask a question?
Instead of calmly proceeding, the defendant repeatedly interrupts and questions the process. The judge firmly reminds him that if the behavior continues, custody for contempt is a real possibility. Despite being represented by counsel, he speaks out of turn and complicates what should have been a straightforward plea. The courtroom atmosphere shifts from routine negotiation to controlled frustration as the judge attempts to keep the hearing on track.
Go ahead, sir.
Can I ask a question?
Go ahead, sir.
After we do this plea, like after I finish my probation and complete everything, like, would I still be able to get my license? Because I like to have my documents intact, in order, and everything.
All right.
I know I was wrong for the case and everything, but like, would I be able to do that?
You have to talk to Mr. Holler about that. He can give you the legal advice.
Okay.
All right, please raise your right hand. You freeze. All right. Do you solemnly swear or affirm the testimony you're about to give today will be the truth?
Yeah.
Yes?
Yes.
Yes.
All right, you can put your hand down. You understand if I accept the plea from you today, sir, you give up or you waive? First of all, you understand that the maximum penalty I can impose if I accept a guilty plea can be up to 5 years in prison.
Yeah.
You understand if I accept the plea from you, sir, you give up or you waive certain constitutional rights.
Yeah.
You understand you waive your right to have a trial by judge or jury.
Yes, sir.
You have your right to remain silent without that silence being used against you.
Understood.
Yes?
Yes, sir.
You have your right to be presumed innocent until proven guilty beyond a reasonable doubt.
I'm gonna say yes to that, but I was already, I'm guilty. Yeah, though. Because they already said I was guilty.
The judge methodically explains the constitutional rights being waived by entering a guilty plea: the right to trial, the right to remain silent, and the presumption of innocence. The defendant acknowledges these rights, though somewhat hesitantly. The court ensures that no threats or promises beyond the plea offer influenced his decision. Everything appears ready to move forward until the factual basis begins.
Yeah.
Is that a yes?
Yes.
Anybody threaten you or force you to get you plead guilty?
No.
Anybody promise you anything beyond what the prosecutors? Anybody promise you anything beyond what the prosecutor's office has offered you to get you plead guilty?
No.
All right. Anybody, Mr. Nate, Mr. Nature, date, time, location, factual basis, please.
Thank you, Your Honor. Mr. Bailey, on February 5th, 2024, in the area of Binder Street in the city of Detroit.
It's Binder, Binder, Binder.
Binder Street in the city of Detroit. At some point, did you have contact with the police that day? At some point, did you have contact with the police that day?
I ain't had no contact with the police. They contacted me.
Right. Okay. You were arrested that day?
Yeah.
Okay. So prior to that, at some point prior to that, did you have a handgun, a pistol?
You said, did I have a handgun, a pistol?
Yeah.
Yeah, I had that big Glocky on me.
And was it concealed in some fashion at some point?
I had a 30 round hanging out the clip. I had a 30 round hanging out. It wasn't concealed. It was a big 30 round on it. It wasn't concealed. But yeah, though, I had it on me.
Okay. Was it in a pocket or under a shirt or something?
No, it was outside. It was sticking out. It was hanging out.
Okay. Was it partially inside of a pocket?
No.
All right.
I had it out.
Mr. Howler, I don't know if you need to have a discussion, but we need to know whether it was concealed or not at some point.
That's what I'm saying. My shit wasn't concealed. That's what I'm saying. I don't even know why I'm going through this. My shit wasn't concealed. It was not concealed.
All right,
Now
Mr.
let's
Holler.
prove it was concealed. I want to go to trial.
Hold on,
You're
Mr.
what?
Bailey. All right, Mr. Bailey.
My gun wasn't concealed. It wasn't concealed.
When asked to describe what happened, the defendant makes statements that contradict the charge. He insists the firearm was not concealed, even while describing circumstances that raise legal questions about partial concealment. This creates a serious problem. The court cannot accept a guilty plea unless there is a clear factual basis supporting the charge. As confusion grows, the judge pauses the process, recognizing that the plea cannot proceed under these inconsistent statements.
Y'all do
Mr.
people
Bailey,
like this, man.
Mr. Bailey, just listen. I'm not going to accept the plea. I'll let you go forward to have a trial. Mr. Holler, you want the examination date?
Yes, I do.
All right, so Mr. Bailey, you're going to be going on. I'm not going to accept any pleas from you today, sir. If you're innocent, we're going to let you go forward and exercise your constitutional rights to have a trial. So we're going to the next stage. So the next stage is at a preliminary examination. Mr. Najer, as it relates to any offers.
Your Honor, it goes forward as a no reduce plea.
All right. So Mr. Tooks, can I have examination track from Mr. Bailey?
Not a problem. It's going to be Judge Sabri.
All right. Mr. Holler, this matter is going on the examination track before the Honorable Judge Aaliyah Sabri for a Zoom PCC May 30th at 8:30 a.m. Again, before the Honorable Judge Aaliyah Sabri for a Zoom PCC May 30th, 8:30 a.m.
Okay. All right, thank you.
All right, Mr. Bailey, you going to the next stage, sir. You going forward to have a preliminary examination, sir. You got that date and time?
Yeah, because I ain't going out like that, man. I can't go out
That's
like
fine.
that, man.
That's fine, sir. You can exercise.
I can't go out like that. That my shit wasn't concealed, man. They trying to play me dirty.
All right, you can go forward, sir, and have a trial. Have a good.
With the defendant maintaining that the weapon was not concealed, the judge declines to accept the plea and places the case on the examination track for a preliminary hearing. The negotiated probation offer remains available only as originally structured, no reductions. What could have ended that day with probation now advances toward further litigation. The hearing closes with the defendant insisting he can't go out like that, while the court calmly transitions the case to the next stage.